Good evening. Today is January 21st, 2021. This is the House Rules Committee. We have a hearing this evening, and before we begin, I would like the clerk to call the roll, please. Here.
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 Here. Thank you. Before we begin the hearing, I'd like to do a little housekeeping. I will entertain a motion to hold for further study the following House resolution bills, number 5002, 5003, 5004, 5006, 5007, 5008, 5009, 5010, 5011, 5023, 5033, and 5036. Do I hear a motion?
So moved.
Motion made by Vice Chairman O'Brien, seconded by Second Vice Chairman Chairperson Vella Wilkinson. All those in favor?
Aye.
Opposed? I think we only have one opposition. The motion carries. We have this is basically a continuation of January 14th. We are going to hear a few bills this evening. We have the pleasure and honor of having my dear friend, Representative Lombardi, here for House Resolution 5023. Representative Lombardi, good evening and welcome to House Rules. I can hear you. I hope that anyone watching can hear you. Is the button up, John? Okay. Okay, good. John, proceed with 5023, please. John, hold on. Let's make sure that everyone can hear you.
Yeah, this one's not, the light doesn't go on.
Is that one working?
Yeah, that's working. This one's working.
Okay with me if it's...
That one works.
Thanks a lot. They're going to disinfect it when I'm done. In other words, I'm polluted. I get it. Listen, I've been thrown out of better joints. I'll see you later.
John, come here. Where you go?
Mr. Chairman, really? Come on. Wow.
Well, listen.
What a thing that is. My God.
Well, John, all I can tell you is we're glad to hear your voice.
Yeah, thank you.
All right, so John, if you wouldn't mind, would
Sure.
you mind proceeding with House Resolution
Sure.
5023? Thank you.
So just for housekeeping purposes, there's too many years on that. I spoke with Nicole this morning, and she said that I should just place into the record that no member shall serve for more than 6 years. So that would be on line 6, 8, and 10.
6, 8, and 10?
Yeah, that should read 6, not 12. What happened, Mr. Chair, I believe, was I have my usual term limit bill,
Yep.
which is a 12-year.
Yep.
And so I think they kind of put it together in the mix-up and with everything that's going on with COVID. So that should be 6 rather than 12.
We will take that into account.
Thank you. So I just want to read a couple of lines, and then I will open it up for questions because I know you're busy. So what we observed with the last election is the use of social media, which will be the wave of the future. Social media allowed many winning candidates to prevail with on-the-ground mobilization, message amplification, raising funds from new and small donors. We must harvest the new potential of the latest technology to assist with our grassroots supporters. So what this legislation does is it will try to discontinue the practice of, one individual or, just a couple of individuals having the power to control any and all legislation. So let's get rid of the authoritarian power that continues to exist. And we can do that, and I've got several, but by adopting term limits for leadership and chairs of committees to 6 years. Remember, process matters, but a legislator may now lobby his colleagues to garner support for his and her legislation. That's what this would do. And one will not have to ask for support from a chosen few as opposed to gather support from the body proper. Please take heed that changes upon our General Assembly. You could see it by the many new people and faces that you've seen. So I am asking you to support in setting our diverse House on a new course of openness, predictability, and transparency. Now is the time to question conventional wisdom in challenging the status quo. And with that, Mr. Chairman, my intent with this is to basically have some kind of rotation, because there are people in this room that in our chamber that have many, many talents, and they're just not being afforded the opportunity to do that. So me, for example, I'm an attorney. I was a school teacher. I have my degree as a principal. I served many, many years in municipal government, and I've never once been afforded an opportunity to sit on any of those committees. So, and I'm just not being parochial in any way, but I think there are many people that have many talents, and this will afford them an opportunity to bring forth their talents to not better themselves, but better the state of Rhode Island, the people of the state of Rhode Island. Thank you, Mr. Chairman. I will, if you have any questions, you probably don't, but if you do, I will endeavor to try and answer them.
Thank you, Representative Lombardi. It's always a pleasure to have you before
Thank you.
House Rules. Are there any questions of the representative?
Thank you, Mr.
No.
Chair, members of the committee.
Thank you, John. I know we have Lita Filippi, who came in a little bit late. Welcome, Lita Filippi, and I know Caucus Chair Diaz, Grace Diaz is here, and it's my understanding that Representative Serper is here with us remotely, correct? Okay. So that concludes the testimony on House Resolution number 5023. I'd next like to bring before the committee House Resolution number 5033 by Representative Donovan. Representative Donovan, you're here today.
I am here.
It's a pleasure to have you here in front of House Rules. Please proceed.
Okay. Can you hear me?
Yes.
Oh, good. Well, thank you, Chairman and members of the committee. It's certainly good to be back working. The resolution 5033 or 53? 5033 would amend the House rules by providing that during any public health emergency, the Speaker would, in his or her discretion, require that members comply with any public health safety measure recommended by the Rhode Island Department of Health while in attendance at any session or committee of the House of Representatives. As some of you may know, I spent my professional life teaching health science. And I respect those who have careers specializing in public health, and I also respect their expertise in their various fields. And that being said, I feel I speak for many with pre-existing conditions who find themselves in the high-risk category, meaning we could become gravely ill if we contract the COVID virus. So I urge you to consider this resolution not only for the health of us all, but for the peace of mind as well. Thank you.
Thank you, Representative Donovan. I think that's a very timely and important piece. Are there any questions of Representative Donovan? No? Representative Donovan, thank you for your participation today.
Thank you. Thank you,
That
Chairman.
ends the testimony on 5033. Last resolution before us this evening is House Resolution number 5036 by Second Vice Chairman Representative Camille Vella-Wilkinson. Representative Wilkinson, turn it over to you.
Thank you very much, Mr. Chairman. Fellow members of the Rules Committee, ladies and gentlemen, House Resolution 5036 would amend the rules of the House to establish a procedure for the discipline of a member, which would include censure, reprimand, and expulsion. This resolution would also provide that a member subject to potential expulsion would be afforded due process of law. So I want to begin my discussion of this rule change to say that it actually had its initiation 3 years ago. I had the good fortune to be part of Representative Tanzi's committee that explored sexual harassment in the workplace in the state of Rhode Island. And the committee came up with a large number of changes and a significant number of bills, and unfortunately not many of them saw the light of day on the floor in terms of a vote. But one of the rules in particular that I had initiated was one dealing with members who were accused of harassing other members. And although sexual harassment was part of that, it was any form of harassment. So I want to make sure to begin with that everyone understands that that is where this rule change initiates from, not anything else. I know I've gotten some calls, emails, and texts from people that are supposing it's for other reasons, and I'm going to tell you, no, this is something that occurred within the last 3 years. Some of you may remember that I had the opportunity to serve the state of Rhode Island on the Rhode Island Commission for Human Rights. And that state agency is responsible for the enforcement of state and federal anti-discrimination laws. My goal in the year that we had the Sexual Harassment Committee, I submitted a bill and recalled it last year, and to give you a heads up, have recalled it for this session as well. That said, for the purposes of any complaints of harassment, elected officials would be treated as employees, and we would follow the standards that any other person would by having a complaint go through the Commission for Human Rights. So as I was thinking of the bills that I plan to recall for this session, it occurred to me that it would make sense to at least start off by having a rule that spoke specifically about discipline. We don't have a definite rule outside of any violations that would fall before the Ethics Commission. So typically, if it was finance, there's a procedure for that, or anything within the realm of the Ethics Commission. And so it was my decision that since the body votes on who the Speaker of the House is, that is why I have identified that the person responsible for meting out discipline would be the Speaker of the House. But I wanted to be sure that due process rights are not violated, and that's why it talks about the opportunity for the member, if he or she has gotten discipline imposed upon them by the Speaker, that within 5 days they have the ability for an appeal hearing, and that would be before the Committee on Conduct, and then it would go to the floor for a 2/3 vote. So that is this bill, or this resolution, I should say, in a nutshell. We don't have anything right now. I wanted to make sure we had a jumping off point. I remind everyone that the rules are reviewed every 2 years. And if this doesn't work out, we have the ability to amend them when the next time the rules come up for consideration. Thank you.
Thank you, Representative Ella Wilkinson. Representative Chairwoman Williams.
Thank you, Chairman. Representative Wilkinson, I would like to know if, often when we talk about harassment and we talk about the ramification that may come when there's a complaint made, I want to know that if your resolution addresses also the perpetrator, and what I mean by that is the person who cries wolf. We think that when we say harassment, it's always a guilty person. But how about the individual that cries wolf, that is a participant? Is there a reprimand, if found guilty, that is brought upon that individual or individuals as well? Does your resolution address that? Because there is instances where the harassment comes from the person who actually is filing the complaint against someone else. If I'm starting out talking Spanglish, so I hope you understood what I'm trying to say here, because it's infuriating to put all of the blame on one side when you may have had a nickel in the quarter. People are often signing checks that their body can't cash. And this is a place that it happens often. And that's where these resolutions and laws and reprimands came out of. So I want to know, respectfully, if it addresses those who cry wolf as well. And if you understood what I'm asking and saying.
Thank you very much for the question, Chairwoman. And I'll tell you, considering that I come from Brooklyn, I'm pretty conversant in Spanglish too, so we're all right. We're good on that. The resolution before you is dealing specifically with discipline. The resolution that you are referring to that would speak about harassment has yet to be introduced to the House yet. So there's a couple of things with regards to if someone files a complaint and it's found to have no merit, I believe, in my humble opinion, that's different than somebody weaponizing the system and sending up a complaint that has no merit and it was done with malice. So the concern, and I've had this kind of conversation before with the ACLU and with Michael Avora from the Commission for Human Rights. The concern that has been expressed to me is if you take action against an individual for filing a complaint of harassment and there isn't proof, then it creates a chilling effect in the event that there is actual harassment in the future, and then other members, depending upon what the response to a false complaint is, it could eventually have a chilling effect. I'm going to take your comments into consideration before I do the full recall of the bill on harassment. But it's basically, we would follow the same procedures and the same steps that are done within the Commission of Human Rights. So that in the commission, if someone files a complaint, you have the hearing officer, and then you have two other hearing officers that are responsible for reading the transcripts. And then that body decides whether or not there was probable cause and what, if any, the penalties would be. In the event of workplace harassment, typically we would ask the individual, what is it that you're looking for? Sometimes they want to be reinstated. Sometimes all they want, frankly, is an apology, a public apology. And that's something that could certainly be taken into account. But that's a different bill. That's outside of this, which is just specifically about disciplinary actions in the House.
Okay.
Yes, this isn't specifically about harassment. This would be any discipline that was taken.
Just so I can kind of maneuver in between both of you to kind of do a clarification also for myself. The resolution before us now has to do with the House rules. You're alluding to a bill outside the rules with regarding harassment. If I'm correct in understanding what Chairwoman Williams is saying, you're talking about let's call it a frivolous complaint, but within the rules but within the confines of the House, not outside the rules. Okay, so I guess what she's trying to say is, does the language does your language also address within the confines of House conduct a frivolous complaint?
Thank you for the clarification, Chairman. No, ma'am. The rule that I submitted stands as is written, but I think that's a good point to consider, and we're holding it for further study, even if it's just for the week, but I'd like to talk to you about that and maybe see what Ledge Council has in mind of how that might be able to be tweaked.
Thank you very much. That's exactly what I'm saying. It belongs in both places.
So I was actually able to act as an interpreter between the two.
Yes,
Boy, will wonders never cease.
yes.
Do we have any other questions? Leader Filippi.
Thank you, Chairman. Yeah, I have a few, sorry about the feedback. Try and move over here. Yeah, I have a few issues with this, and I like the intent of it. I took the liberty of looking at the rules of the United States Senate Committee on Conduct, and I would just urge you guys to take a look at how they make sure a target has due process. They allow the target the power of subpoena through the chair as well. And I don't see that the target has subpoena power. I see that the committee does. And I just want to make sure that that is a right that a target has. These can be politically charged. These hearings can be politically charged. If the speaker is the one pushing a hearing, there may be a reticence on behalf of the committee to provide subpoena power to a target solely at the target's request. I think the target should have the right to conduct that necessary discovery that they get in civil processes every day in the state. That's a more specific issue. I think on a more macro level, I'm concerned about what we're doing here. What this essentially does is it centralizes the power to censure and expel in the speaker. When we read the article in our state constitution that deals with rules of houses and contempt, to quote, it says, each house may determine its rules of proceedings, comma, punish contempts, punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member, but not a second time for the same cause. When I read that, I think it's clear that the power to discipline unruly members is a power that is inherent in the body, the membership of the body. And I'd be concerned about these rules restricting that power to just being in the speaker's hands. And I'll give an example as to where I think that would be problematic. Right now, the only remedy this body has for a speaker that, let's say, use an extreme example, is arrested and put in jail, right? If that were to happen, the speaker says, I'm not stepping down, I'm not resigning, I'm going to use my speakership as a bargaining chip with the authorities. At that point, the only remedy this body has is the power of expulsion. The speaker, it's a 2-year term. There's no way that this body can change who our speaker is. We can always do votes of no confidence, and at that point, it's up to the speaker to step down. But they have discretion as to whether or not to step down. If we pass this rule, then we could have an intransient speaker who says, I'm not going to evict myself from the House, and I'm the only one with the power to expel myself. And the body would be left with the only alternative is coming back to the chairman here and seeking a rules change. I don't think we should be setting up rules, Mr. Chairman.
With all due respect, and so I don't get lost in the conversation here, because the speaker's position is a constitutional one, are there any rules that can be used to force him out?
So the only rule that we have to force a speaker out is the expulsion from the body. At that point, by its very nature, the seat would be empty. So under Article 6, Section 7, this body can expel any member. If we were to expel a sitting speaker, that speaker's seat would now be empty.
But again, because it's a constitutional office, would that apply?
Of course. I think if someone is no longer a representative, they can no longer be, they are no longer the speaker, period. And so what we're doing, Mr. Chairman, is we're taking away the power of the body, which has this necessary check on a speaker. And because we're doing that by saying the only way expulsion can commence is by the speaker commencing it. Whereas under our current rule system, any one of the members can commence it.
So let's take the speaker out of the equation. What about the rules as it stands? If not with regard to how it applies or doesn't apply to the speaker. how do you feel about the rest of it?
So the example of the speaker, it's an illustration of the larger point. And the larger point is that the power to discipline is inherent in the body in Article 6, Section 7 of our state constitution. It says each house may punish contempts. And so what
I'm sorry, may punish what?
Each house may punish contempts, punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member. And so what this is doing, it's taking the power of discipline away from the body and centralizing it in one member, the speaker. Now, it's even more problematic, Mr. Chairman, when we deal with censure. So the first part says that only the speaker can commence a petition to expel. However, if it's censure or reprimand, the speaker can unilaterally censure or reprimand, subject to appeal by the reprimanded member to the committee. I think that even goes further by saying, okay, we're saying the speaker can commence, only the speaker can commence a proceeding, but in this instance with reprimand, we're saying the speaker can commence and unilaterally censure, and then the member only has a right of appeal. I don't think the speaker can have that type of authority to unilaterally issue censure or reprimand under our state constitution. It is a power that is clearly inherent in the body.
You bring up some interesting points we're going to have to review.
Please. And I understand the intent. I think it's great we're putting due process and procedures for our conduct committee. I saw that and that's something we need. But I think we really have to think long and hard about the structure and what we're doing with this rules amendment.
There is something to be said, though, for the buck stopping at the top, especially with regard to censure, to discipline, etc. So I think with regard to the actual language, I think that's what the intent is.
I understand the intent all day long. I do. And as a member of the minority party, this may actually protect our members, right? Because when is the minority ever going to be able to gather the 2/3 necessary to expel or the majority necessary to censure? Hopefully soon, but maybe not. But I
wouldn't hold your breath, leader.
But it is a structural issue, and it's something we all should be very concerned of the further aggregation of a significant, important constitutional power in the speakership. And I don't think that's something we should be doing. I always say, Mr. Chairman, the road to hell is paved with good intentions. And I think this is one of those instances where it's far more prudent to have this incredible power retained in the membership and not have the speaker be the funnel for expulsion and the funnel and the hammer for reprimand or censure. I think it's very problematic.
I think your comments will be taken under advisement.
Thank you very much, Mr. Chairman.
Representative Newberry.
Thank you, Mr. Chairman. Just to follow up on that, one possibility that if you wanted to create more of a limited number of pool of people to could censure, you could have it be or move to expel. It could be a vote of 2 of the 3, Speaker, Majority Leader, Minority Leader. And the reason I bring it up is the discussion that Leader Filippi brought up about the speakership. We all know who I'm talking about, but we had a recent speaker go to federal prison. And the reality is that if a speaker is losing control of the job for purely political reasons, normal stuff, and there's a vote of no confidence, that speaker is going to be forced to step down because they won't be able to do the things they want to do in the speakership. They're going to voluntarily resign if they can't get half the 2/3 for a budget vote or whatever. We all know the politics of it. But hypothetically, if you had a Speaker of the House who got jammed up on some type of legitimate criminal charge in, say, April of the beginning of the first of a 2-year term, so they still have 20 months left. And, the criminal process doesn't move overnight. You get indicted, you investigate it, et cetera. By the time that person ends up in jail, if it gets to that point, it's going to be a year or more out. The Speaker gets double the salary. Okay, so you're talking at this point about $32,000. They get health benefits, which can be a family plan, getting up there. You could be having a $60,000 financial hit to that person if they were to resign. They'd have no, again, we're not talking honor here. We're talking practically, somebody's under criminal investigation and indictment. They probably have other issues anyway. They have no incentive financially. They might need that money to live on while they're being charged. And even if they're found innocent, so they may have every incentive to thumb their nose and say, I'm not stepping down. And that becomes the issue, what do we do? And that's the problem. It sounds hypothetical, but, it could have happened. Could have happened as recently as, 7 or 8 years ago. So it could happen.
Thank you, Representative Newberry. Chairwoman Williams.
Thank you. I appreciate Representative Filippi's explanation that he gave. I mean, it's like bullseye. But I would ask, with all the effort and that study, because you went in on this, what is your suggestion? It's oftentimes we identify a problem, but we don't take the time or use the time, or for whatever reason, don't present what I suggest. Here is something that would address this, and there's others, but this is what I think is the best. So I'm just asking, by virtue of you bringing that to light, what are, if any, suggestions you would present in place to eliminate the problem that you brought to light?
So, as it is an inherent expulsion, reprimand, censure are inherent powers under our state constitution in the body, the process really is that any member has that authority to submit a resolution proposing expulsion, censure, or reprimand, and it would go through the conduct committee process with the due process, which I think Representative Bell Wilkinson astutely believes we need, and I agree 100%, but any member has the power to put in a resolution, and the process plays out. You know, it's not clean, and it could be abused.
And if I may, and I know that's where you were leading through your earlier testimony regarding the bill, but boy, let me tell you, that could really, really be abused.
So
And for political reasons or for personal reasons, that's very problematic.
it's what we have now, Chairman. It's what we've had since 1843 when our Constitution was enacted. We've had it for 177 years. And I don't believe it's been abused.
But so when you're looking at the fact that the abuse by the majority, let's say, is a possibility, just as Representative Newberry said, if you have the possibility of a speaker who gets jammed up, which we've seen, okay, is there any merit to having the trigger be set off by one person, e.g. the speaker?
I think the potential, and I think removing the authority from the body is fraught with issues, and I think the good might be outweighed by the bad. Is there a middle ground, a compromise where the speaker or the majority leader or the minority leader can institute expulsion, censure, reprimand proceeding? There's merit to that compromise. But I will say, this has been the status for a long time, and I don't know that it's been abused. You guys have been here longer than I, but I've always paid attention to Rhode Island politics, and I don't ever remember this type of thing being abused. And if it were to be abused, like, we wouldn't allow an abusive resolution to really move forward. I think a representative to come out and do something like this would be putting their own reputation on the line. And frankly, if they allege facts that weren't true and tried to abuse the process, that abuse of the process would subject them to expulsion, censure, or reprimand. So, this isn't something where you can just come in and start throwing allegations around without a hammer being held over your neck as well.
Well, I think there's a number of double-edged swords here.
Yeah.
Chairman McNamara.
Yes, thank you, and thank you, Lita. That was very interesting, and I love the fact that you brought up the United States Senate. I was thinking of the next trial that they're going to have, where they have, in front of the Senate, they have attorneys for the defendant and the prosecutors. But I'm reflecting back, and I did earlier, when I saw this amendment, to maybe, 15 years ago, Madam Chair? Around 15 years ago, there was an individual from one of our urban cities who was a minority individual. And I remember one of my colleagues from Warwick, freshman, freshmen always do this, I don't know, immediately calling for his resignation. And I remember going up to my colleague, and this individual had not been convicted of a crime, and telling him, look, you probably, he was an upper middle class attorney, have never lived in a three-family. You probably don't even know what a gas-on-gas stove is. You have no idea what type of environment this individual has been raised in and what the cultural norms are. So that is a fear that I have. Very often we see people that make snap judgments, and I think we heard some of that today. They want a headline coming down on someone, clearly in violation of, as I said before, Rule 10B, where you're questioning the integrity and character of another rep before you have the facts. So that's just my fear, Mr. Chairman, is that there is room for abuse in this, and sometimes people, when they head into these types of procedures, they're not as respectful as they should be, and sometimes they even can lack cultural understanding, because we are a diverse body. So that makes me very cautious, Mr. Chairman, about these types of rules. So,
Point
I appreciate.
Point taken, Mr. Chairman,
Thank you.
thank you. Any other questions of Representative Ella Wilkinson? Thank you. At this time, we have some individuals who will be testifying remotely. I'd like to start with Steve Brown from the ACLU, if you could get him on the phone. Mr. Brown, are you with us?
I am.
Welcome to House Rules for your second appearance in a week.
Yes, thank you very much, Chair. I appreciate the opportunity.
Please proceed.
Thank you. First, I do want to commend Representative Ella Wilkinson for putting in this resolution. It's important to have some standards in place, something in place if the House is going to have this power to discipline, which it has. And from experience, I just point to what happened a few years ago when the Senate considered expelling a member. They were literally making up the rules as they went along because they had not thought in advance of adopting rules to address the issue. We also obviously support the notions of due process that are in the resolution. However, like Representative Filippi, we'd encourage the committee to consider, are there additional specific provisions of due process that should be baked into the resolution itself in order to ensure that the proceedings are fair. We haven't had time, since the resolution was only introduced 2 days ago, to see how other states do it, but obviously due process is very important to us. There are two particular provisions, though, that I want to briefly address. One that has been talked about a lot is this notion of who has the right to censure or reprimand an individual. And we agree that it's of concern that it lies only with the speaker to do that. Although our concern is slightly different. I understand the concern about having 70 plus people being able to do it, but our concern is that the way the resolution is drafted, it's the speaker who has this very enormous power to unilaterally impose this discipline by him or herself. It's not just introducing a resolution when it comes to censure or reprimand, it's actual conduct. So the speaker, on his or her own, imposes that discipline, and nobody else has an opportunity to raise concerns, consider censure or reprimand, and we think it's problematic because it gives the speaker enormous power to punish individuals on his or her own. Even though the individual ultimately has a right to appeal, the damage may be done by the imposition of the discipline in the first place. The second point I wanted to raise has to do with what are the standards for expulsion as opposed to censure reprimand. I think in those instances the standards can be very broad, but we believe that before considering the actual expulsion of an individual from the legislature, it's there should be at least some basic criteria as to what type of misconduct will potentially lead to expulsion. Because when you're talking about that as opposed to a reprimand, what you're talking about is disenfranchising a community, a district that elected this person to represent them, and the House is taking it upon itself to essentially reject what the constituents, what the members of that district did in electing this person. And we think the standard ought to be quite high before that can happen. And in order to ensure that, we would encourage that some sort of standards be in place as to when expulsion is authorized, as opposed to just leaving it up broadly, referencing misconduct or, the very vague language that's in the Constitution itself. So we hope you'll give those thoughts of ours some consideration. And again, we appreciate that this issue is being debated and discussed because it is an important one.
Thank you, Mr. Brown. I failed to say for the record that Mr. Brown is the Executive Director of the ACLU. Are there any questions of Mr. Brown?
No.
Representative Place.
Thank you, Mr. Chairman. Thank you, Mr. Brown, for testifying before us today. This is a way to introduce this concept as a question to Mr. Brown. But I guess the key thing on this that we're discussing is allowing the speaker to be the only one to initiate the process. And I was wondering, both from the committee's perspective and from Mr. Brown's perspective, is there a way that we could establish, say, a number of representatives that would have to sponsor the petition? So again, we're not allowing one rep to initiate an action like this, but say not 10, but say 1/3 of the body or something like that would be required to acknowledge that the conduct in question would be, would reach the merits of an expulsion, or at least the hearing, and therefore require the speaker to either start the petition or, sponsor the needed resolution, or just with 1/3 of the body sponsoring it, having it go forward from there.
Well, I think that's a good point, an interesting point. I do want to make the distinction between expulsion and censure, expulsion on one hand and censure or reprimand on the other, because in the latter situation, there really isn't an initiation of the process. It happens. The speaker imposes, censures or reprimands the individual as the resolution is worded. So there is no process really until after the individual decides to appeal, if they appeal. On the expulsion issue, I think coming up with some sort of process, such as you're recommending or suggesting or throwing out there, makes sense. Again, we really haven't had time to think it all through, but I think trying to come up with those sorts of approaches to avoid this unilateral aspect of things would be appropriate.
Thank you. Any other questions? Thank you, Mr. Brown.
Thank you.
Next, we have John Marion from Common Cause. Could you get him on the phone, please? Mr. Marion?
Yes.
Hi, this is the House Rules Committee this evening. Mr. Marion is the Executive Director of Common Cause. Please proceed.
Great. Thank you, Mr. Chairman. Thank you, members of the committee. We want to thank the sponsor for putting this in. As Steve just said to you, we've raised concerns in the past when the Senate tried to hastily put in rules before there were problems. And so now is the time for you to be doing what you're doing, vetting this proposal and making improvements. We want to suggest a few improvements of our own. Most of these you've already heard before. We think it's an obvious flaw that these flow through the speaker exclusively. As Representative Newberry pointed out, what if it were the speaker? Given the power invested in that office by the rules, that person is a target of many attempts to influence their behavior. and many temptations. So the chances that a speaker runs afoul can be pretty high. And we've seen that both in our state and in neighboring states. So we think there should be some at least alternative chain of command, so to speak, for a complaint that involves the speaker. If they're the subject of the complaint. You also heard from the ACLU that perhaps you need to look at greater due process for the accused here, and we think that that's important. I would also suggest I looked at the Massachusetts rules and actually build into their rules a process for referral by things like their equivalent of the State Human Rights Commission. I would think you might want to build in some language to allow them to make referrals or allow the State Ethics Commission, which also has jurisdiction over your behavior, to make referrals, because there will be instances where they receive complaints that perhaps don't fall under the Code of Ethics, but might be appropriate for, might run afoul of your rules. I would also just like to point out that there probably should be some timeline built into this, and some indication of who would conduct an investigation. Would it be General Assembly staff? What if it's staff supervised by the person who's being investigated? Those are the sorts of questions we think you need to answer. And finally, just think about transparency. There are varying levels of transparency when it comes to ethics, typically. So our State Ethics Commission is among the most transparent in the country because they make all complaints public. That is something you have to weigh. When does this become public? When does the work product of the investigation or the committee become public? And that's something that I think would be beneficial for you to decide now, rather than wait until you have a complaint in front of the committee, and they have to make that up as they go along. So I'll stop there. Again, thank you for considering this. I think it's incredibly important, and I'd be happy to answer questions.
Thank you, Mr. Marion. Chairman McNamara.
Thank you, Mr. Marion, and Mr. Chairman, members of the committee. Last week, I had the opportunity to discuss a matter with a representative from the Massachusetts House of Representatives, and she mentioned to me that the day before their inauguration, the Massachusetts House of Representatives adjourned at 4:30 a.m. in the morning. Mr. Marion, I would suggest that the Massachusetts House of Representatives look at our rules and the Rhode Island House of Representatives, because we've eliminated that type of behavior. And I think that we have to look at other states with a cautious eye when we start to just replicate rules that everything seems better once you cross the state line. As they said in Porgy and Bess, it ain't necessarily so. So thank you very much. I appreciate your comments.
Thank you, Mr. Chairman. I don't want to start a border war.
Thank you, Chairman. Leader Filippi, do you have a question?
Not for the witnesses. I have a statement question on one of the bills. I just want to raise it before we adjourn.
Before we get to, not regarding this resolution?
No, Mr. Chairman.
Okay, why don't we wait then till the end? Chairwoman Williams, did you have a question? No.
To Mr. Marion, I want to know, first and foremost, your suggestions. I couldn't write as fast as you was talking. Could you have all of that in writing and send it to us, please?
Absolutely, Chairwoman. I will do that tomorrow.
Thank you.
Any other questions of Mr. Marion? Mr. Marion, thank you for your participation this afternoon.
Thank you.
Leader Filippi, you had a question.
Thank you, Mr. Chairman. Excuse me. It was more of a comment on H5002, your House resolution. It's something that the Minority Caucus have batted around for a long time, and a lot of our Democratic colleagues agree, is that we need some procedure for committee chairs to swear in executive branch witnesses. I'll just be frank, there's times we've been lied to, blatantly been lied to in our committees, especially oversight. In many other places, I'll just look at the United States Congress, every witness gets sworn in. I think at the very least, administration officials who come before our committees must be sworn in under penalties of perjury, and potentially lobbyists should be sworn in. I think that's something necessary to preserve the integrity of our committee process. Thank you, Mr. Chair.
I second the motion.
Leader Flipper, I believe that Chairwoman Williams is taking you out to dinner tonight. Before we, I know this is a little off track, but Speaker Pro Tem Kennedy, I believe you had a comment.
Yes. So a long time ago, I had a legislative commission, and one of the issues we ran into is the fact that to be able to do this, as far as to swear them in under penalty of perjury, you need to have some type of thing that not only do we have to pass it in the House rules, but then for each meeting, the speaker basically was required to have to give that permission to sign off on the fact that you had to do this. So I'm not sure if this may end up being a convoluted process, and I understand what you're trying to say, that perhaps we need to have some type of process in place. I'm just concerned that it may take us down a road where we may run into some problems later on. But I would like to see something like this happen in some format.
Thank you, Chairman. It is the Speaker's province to issue subpoenas. Subpoenas must be under his or her hand. That is not the same for testimony. I don't believe it is. I believe that any person authorized to administer oaths would be able to, at that point, provide an oath. And I think when you look at our statute, it's broad enough to have the penalty of perjury come under to lying to a committee. So I think there's a way to do it without it being cumbersome, and I think we really have to look at it.
Before I turn it over again to Chairwoman Williams, on the penalty of perjury, so what would the penalty be if we found that there was perjury?
So if there was
the committee found that there was perjury.
So if the committee found that there was perjury, like any felony, it would be referred to the Office of Attorney General, and under our general laws, it's punishable by up to 20 years in prison. I mean, it would be rare that anyone would receive substantial jail time, but there is a substantial penalty associated with this crime.
Would there be, or would this therefore, let's say we were to put something into the rules regarding this, would we therefore have to have a corresponding public bill be outside of the venue of the rules? That would speak to this particular type of perjury?
I don't believe so.
This particular type of action?
Yeah, I don't believe so. I believe we have a criminal statute on point already, and that providing false testimony, because right now we don't have testimony. We just have people coming and speaking on a microphone and giving their opinion, and they could lie to us left and right. By swearing someone in, at that point it would become testimony, and they would be under the rubric of that existing criminal law. I mean, would we have to pass some other statute? I don't believe so.
I'm going to tell you, I can see where this would be abused. I can see where this would. Let me tell you, I'm putting a whole bunch of scenarios in my head right now where if I wanted to be an unscrupulous individual with a particular advocacy, I could really nail my opponents to a wall.
So that's why I want to limit it to administration officials. Like, I don't believe this should be used on your regular guy off the street coming to testify on one of our bills. But when we have administration officials actively lying to our committees, there must be.
You're absolutely correct. But the wording would also envelop other individuals also.
Well, we could limit it to executive or branch officials and lobbyists.
We would have to take a very careful look at that.
Agree. I'm not saying that we should do this, shoot first and ask questions later, but this is a real problem we face, and it's something we must address.
Representative Williams.
Thank you, Mr. Chair, and thank you, Minority Leader Filippi. You're on a roll tonight. I thank you for that. Not that you're not often, but you are tonight. But I have to agree with you as a member of Oversight and a member of several other committees. These department heads, they are off the hinges. Better began January 1st, 2021. That of what Minority Leader Filippi just brought to light needs to be a priority. Those top administrators who come and laugh at us, look at us in our faces and laugh at us. Brett Smiley is one of them, that we're waiting for documents right now, and he's laughing right now as he's listening to this testimony, needs to be put on blast, because there are things that we're getting blamed for because of these department heads that are not being held accountable. DHS, DOA, DCYF, the list is long. Let's work on that one, and I'm asking that to be a priority in this committee. Thank you.
Thank you, Chairman Williams. Caucus Chair Diaz.
Thank you, Mr. Chairman. And I agree with Rep. Williams. You are in the mission tonight, Leader Filippi. And I agree with you. On top of all the things we have said tonight, is sending a great message to people when they come to testify to the State House. Because it's easy for people to grab some information in the street and come here and blast us with all the lies and things possible without any consequences. So with that, people will pay attention, including department directors, including people from our community, and they will take serious the opportunity to come here and testify. So I agree 100% with you. And from the Democratic Party, I want to tell you that you are absolutely right tonight. Thank you.
Thank you, Caucus Chair Diaz. We have Representatives, Chairwoman Serpa, who would like to weigh in on this issue. Chairwoman.
Thank you, Chairman. Can you? Thank you. Okay.
We have you.
Can you hear me?
Yes.
Okay, thank you, Chairman. I'm sorry for the delay. I'm glad Leader Filippi brought this subject up. I think a number of us have been disturbed by the misleading comments that administrators fill our heads with, frankly, when they come to committee. I think Rep. Williams and Rep. Diaz and Leader Filippi are right on with their comments, and maybe we can't come to agreement immediately, but I think this is a subject that needs to be worked on. And unfortunately, experience has shown us that these administrators don't take the testimony seriously. They do laugh at us. I mean, this is a small state. We all have friends and relatives and constituents who work in these administrative departments, and we know that some of the administrators talk about many of us when they go back to the office the next day. They have pet nicknames for us, and that's beside the point. But all we're trying to get at is the truth. What good is oversight, as Rep. Diaz said, if they can come to us, tell us what they think we want to hear, or what will keep them from holding their feet to the fire if there are no consequences. We get feedback in real time during these oversight meetings. I get text messages, I get Facebook messages, we get feedback after committee hearings. It really is very frustrating, Chairman, to have an oversight committee. We're trying to hold these administrators accountable, and frankly, it's for the betterment of our constituency. So I would really like to do some more work on this and maybe amend the rules at some point. I know there is some pressure to get some rules out so we can get the committees formed, and I understand that. We need to get to work. But if this is something we could work on and perhaps amend the rules at a later date, if the membership is willing, I'm just wondering if it's a possibility.
I think it's a possibility, Chairwoman Williams. I think I'm sorry. Don't say I ever forget you. Thank you, Chairwoman Serpa. I think there's a common thread here tonight, and I alluded to it earlier when I was speaking with Leader Filippi. It seems to be more of those individuals who are in an official capacity, who are presenting information or who are supposed to be presenting information in front of our committees so we can gather statistics, etc., as opposed to the regular man off the street. I think a distinction has to be made there. Second Vice Chairman Vella Wilkinson would like to speak.
Thank you very much, Mr. Chairman. Not to pile on, but last year I did have the opportunity, it was towards the end of the session, but I did introduce a bill that specifically asked that, and members of the executive branch coming in to provide testimony in front of any of our committees would be required to take an oath and would be held accountable for misrepresenting us. We have to rely on the information that we get from the executive branch. And as many of my colleagues from the Finance Committee, we know that while we're here in room 35 asking questions of the department heads and any of the other policy folks, we're getting text messages at the same time from employees that are saying they're lying to you. Well, what are we supposed to do? Nothing. We have to eat it. And unfortunately, it's not just that the frustration that we feel, as Chairwoman Williams had said, but when you're dealing with finance and we're dealing with the spending and the overspending, ridiculousness in terms of some of the money that was spent, like for CCRI, as Representative O'Brien and I had been beating our heads against the wall last session. It's passing all of that frustration onto the pocketbooks of our constituents, who, when we go door to door, and it doesn't have to be an election year, many of us are in the communities for graduations or just to see the people in our neighborhoods when we go get a cup of coffee, who say, do you know that everything that they just said to you was a bunch of BS, and you guys are just sitting there? And so what are we supposed to do? And even after we find that they were lying to us, there isn't anything to do. We definitely need that. Now, when we had looked at this as an issue, originally when I did the research, my concern was having it as a rule puts it as a resolution as opposed to making it a bill and it becomes law. I was under the impression that it would have more weight, more heft, if it was actually a law. I will tell this body that was one of the pieces of legislation that I have recalled. So if we do it as a rule, that's fine. I've also recalled it as a bill, and it specifically does have the language to say members of the executive branch. I don't want people from the general public to think, oh, now, if I say something, if I misquote a source, I'm going to be held in contempt for lying to the House. That's not what this is about. This is about our reliance on the third leg of the stool, as they say, relying on the information that they provide to us so that we can write good bills, good laws, garbage in, garbage out. And if we're relying on information we're getting from the executive branch and we can't because it's faulty and because the department heads are in lockstep to lie to us, then, what are we doing here? We're writing legislation just to make ourselves feel good, to put our name on a piece of paper. I don't need busy work. I'm busy enough. I don't need to come up here and do busy work. I want to do the people's work. And I think that requiring members of the executive branch to take an oath that what they're providing to us is the truth is going to go a long way to make sure we are truly doing the people's work. And then it goes to the issue of transparency, of course. And so if we're looking at accountability, because I believe that would be a rule dealing with the accountability of witnesses coming before us, then the original bill that or rule I should say, in talking about discipline that would be meted out to members of the House is another issue of accountability. And I think that we're ready for that. We've been wanting that, the whole issue of accountability on a national platform all the way to the state and hopefully into the municipalities as well. If people need to be held accountable for what they're doing. We're grown-ups, presumably, but, we're doing a grown-up's work, and we need to make sure that we're keeping integrity in the office. Thank you, Mr. Chairman.
We could, and this is just a suggestion, we could limit it to... We could be limiting, and again, this is just off the cuff, we could limit to just government officials. First Vice Chairman O'Brien and then Representative Phillips.
I just couldn't agree more with my colleague. Last year, we did have incidents on finance where we were outright lied to. When we're talking about full-time employees, how many new hires you have, and they just said, oh, we don't have any new-time hires. Come find out, they had about 4 or 5 new hires. So they just look at us, they ignore us, and then they go away. That was an outright lie. And she or anybody who does that through this, any committee, should be held accountable. They should be referred to the Attorney General for perjury.
Thank you.
That's my opinion.
Thank you, Representative O'Brien. Representative Phillips.
Thank you, Chairman. Just to go further, I think we're pigeonholing ourselves. We're just doing executives in the administration itself, because I can see a scenario coming down that the executive itself, let's say the director of the DCYF or DOT or any department, will just pass the buck on to somebody else that works for them so that they're not going to be charged with perjury. And are we going to be delving down into the people that work for them too? I mean, if Leader Filippi, I know you're the lead on this one right now, and I just see, with them saying passing the buck off to somebody else, so they won't get caught in a lie, but they're going to force the other person to lie for them.
So I think it's important for us to be cognizant of what are the elements of perjury. It's not making a mistake. It's not presenting us with evidence that you thought to be true at the time you presented it. The elements of perjury are knowingly misrepresenting facts to the committee. And if you are an underling in the DOT and you come here and you knowingly misrepresent facts, then you should be charged with a crime. And you know what else is a crime? Subordinate perjury. So if there is a department head who tells one of their underlings to come here and lie and commit perjury, the crime goes up to that person subordinating perjury as well. So I think if we have this, I don't think anyone's going to be playing around. I really don't. I think we're going to get a lot more honesty, or maybe they just won't show up. And frankly, that's better than them coming here and lying to us.
Well, I was just wondering if we were going to let the executive get away with it because they have a subordinate that does it.
Well, if there is an executive official who refuses to come to our committee, at that point, the Speaker's constitutional subpoena power comes into play.
Okay.
Right, where we will subpoena people and bring them here, and they will be forced to testify truthfully or assert the Fifth Amendment. The choice is theirs at that point. Thank you.
Thank you, Chairman.
Thank you, Representative Phillips. Representative Casimiro.
I just want to chime in on everything that's being said here, because I agree with everything that's being said. Particularly in oversight, we've had departments come in and we've asked questions that we all know the answer to. Even the committee members know the answer to it, and we're told they don't know and they're going to get back to us, and they never get back to us. So I totally support the direction that this conversation is going in, because we do need people in front of us who are going to tell us the truth. So thank you.
Thank you, Representative Casimiro. Was there any more discussion on this? Representative Azanaro.
Yeah, I didn't want to think I fell asleep back here. I think it's a good idea. One of my questions would be, I know from past experience on the town council, when a lawyer came before us at the council meeting, had to be sworn in. And who has the authority, or who do we give the authority to swear these people in? Because there has to be someone that does that.
Any notary has the power to administer oaths. Most of us, I think, have the power to administer oaths if you've applied to the Secretary of State to be notaries. You know, and to your point, Chairman, when people go testify in front of a planning board, a zoning board, in our towns, they're sworn in. I mean, the fact that we don't do it here, it makes us look like a joke.
I just think there should be someone that is involved with the committee, that they come before the finance committee, the oversight committee, whatever committee, to say the clerk's going to be the person to swear them in, or the chairman of the committee, or a notary that has to be there.
Agree completely. We'd have to obviously have someone there, but if you are a notary, you can administer oaths. Thank you.
Thank you. Thank you, Chairman Azanaro. Thank you. And again, thank you, Leader Filippi, for bringing this up. We have one last individual who's going to testify tonight. We have Randall Rose. If you could get the gentleman on the phone, please. Mr. Rose?
Yes.
Yes. Welcome to House Rules. You may proceed.
Thank you, Mr. Chair and members of the committee. So it seems, can you hear?
Yes, we can hear you perfectly, Mr. Rose.
Thank you. It seems our discussion has
Mr. Rose?
Thank you. Sorry, I'm getting a tape delay. Just a minute. Let me see if I can cancel this tape delay. Okay. In any case, it seems our discussion has moved on some. We've started talking about how the committees can compel testimony and under oath. I think that's an important discussion, so let me just say something about it quickly. The relevant section of state law is Rhode Island General Law 22, Rhode Island General Law 22-6-2.1, and that section of law says that section of law can and should be changed to allow committees to take testimony under oath. And there's also been other problems we've had with that section of law in the past. In the 38 Studios scandal, the Oversight Committee wanted to subpoena somebody, but he had moved out of state, and that section of law wasn't written well enough, so it couldn't compel subpoenas for people out of state. So it needs to be modified so that committees can subpoena people who were in the state at the time but have moved out of state since then. Also that section of law has a restriction on it that only standing committees can compel testimony. I think it should be any committee or commission. And one of the biggest flaws of that section of law is that it says all subpoenas require the approval of the Speaker. That's not from the Constitution. The only requirement for the Speaker to sign off on subpoenas is from that section of law. And that means that if you're investigating wrongdoing by the Speaker, you cannot subpoena the Speaker. So that definitely needs to be changed. As we saw in Illinois a couple months ago, there was the Speaker there was forced to step down in the scandal, and the committee did have to issue subpoenas to him. But in Rhode Island, we're in a much worse situation. If there's a Speaker who's corrupt or whatever, we can't even subpoena the Speaker because that section of law says that only the Speaker can approve subpoenas by committees. So that definitely should be changed. There should be the freedom to subpoena whatever the committee votes for matters necessary to their business. So so I just wanted to draw those things to your attention. That is a section of law that needs to be reformed, and there are a number of changes that need to be made to it. But I wanted to go back to Representative Ella Wilkinson's bill, if that's okay, because that was the official subject for tonight.
Certainly, Mr. Rose, proceed.
Okay, thank you. So unfortunately, this bill is very much unconstitutional. I know the bill was claimed to be a way to provide due process, and perhaps that was the intention, but it actually has some serious due process problems. In some way, it's worse than what happens at present. So it provides less due process than we have now, in my opinion. The biggest problem, as has been alluded to before, is that it's very much unconstitutional. The Constitution says that any member of the House can be expelled with a 2/3 vote. This bill makes it completely impossible to expel a speaker because only the speaker can request expulsion. And that's contrary to the Constitution, because under the Constitution, the House has the inherent right to expel anyone, even someone as powerful as a speaker. And if the House adopts this unconstitutional rule, it will be basically denying the ability to discipline the speakers. And we've seen in other states, not to mention here, that speakers tend to get into scandals in other states much more often than ordinary reps do. I've already mentioned how Speaker Madigan in Illinois was just forced to step down last week. There have been several examples in Massachusetts and so on. It is completely wrong and unconstitutional to make it impossible to expel the speaker, and a cosmetic change that said that to expel the speaker, you need the authority of one of the speaker's leadership team, like the majority leader. That wouldn't make much difference, because if you say that expelling the speaker requires the majority leader's consent, the majority leader is part of the leadership team that's appointed by the speaker, who is basically put in that office to be the deputy to the speaker. It should be, as one of the earlier representatives was saying, it should be that a vote of the reps is enough to expel a speaker, and it should be 2/3 of all a 2/3 majority, as it says in the Constitution, should be enough for expelling. This bill says that if it imposes a stricter requirement than a 2/3 vote, it says that if people refuse to vote on expulsion, if they vote present or if they're not there for the vote, that's counted the same as a no vote, which is not what the Constitution says. The Constitution just provides for a regular 2/3 majority vote to expel the speaker, and this bill changes that requirement and says that if the speaker says that representatives who don't participate in a vote on expulsion, the Constitution says it's a 2/3 majority required to expel any member, and this bill says that representatives who don't participate in the vote are counted as no vote, which is not what the Constitution says. So in two ways, this is unconstitutional. First, in blocking the speaker from being expelled, and second, in requiring more than a 2/3 majority for the expulsion. There are a number of other drafting problems with this bill. But the common thread with a lot of the problems with the bill is that it gives the speaker really excessive control over the process. It says that the bill apparently implies that the Committee of Conduct cannot, when their Committee of Conduct is investigating an expulsion case, they cannot call witnesses without the speaker's consent. Even if a witness is willing to appear, this bill only provides for witnesses who are called by subpoena with the speaker signing off on it. And it would be much better for the bill to allow witnesses and documents to be considered that are submitted voluntarily without any, if people are willing to appear or submit documents without requiring a subpoena, those witnesses and documents should be able to be considered. The bill, unfortunately, seems to imply that no witnesses or documents can be considered except pursuant to a subpoena that is signed by the speaker, and there's no reason you have to do it. It's completely legal under current law for committees to call witnesses and take documents that are willingly submitted without subpoenas, And as I said, the law on subpoenas should be changed so that subpoenas can be issued without the speaker's say-so, particularly when you're investigating the speaker themselves, because often the speaker is going to be the one who needs investigation. I'm sorry for my voice. I'm a little sick today. But the bill is also in conflict with our current procedure in Rule 46 of the House for sexual harassment. In a number of places, it conflicts with the sexual harassment policies, and it makes it very cumbersome and difficult to expel someone who is guilty of sexual harassment because the requirements in this bill for expulsion conflict with the requirements under Rule 46 for sexual harassment cases. So I realize that the bill does somewhat protect ordinary members from expulsion. On the whole, it makes it less likely that an ordinary member could be expelled for bad conduct. But most of what the bill does is to insert the speaker into the process at any turn. At every turn, the speaker can assign the investigation to one committee or another. If the committee does recommend expulsion, the speaker doesn't have to take it up on the floor. The speaker can put it off forever. And the speaker can always remove people on the committees doing the expulsion and has a lot of say over what subpoenas get issued. On the whole, it makes the process much more corrupt. And even though this bill was claimed to provide due process, in a way it provides less due process because if a representative is accused and goes to a hearing, the representative can't be assured of being able to call witnesses or provide documents that they want because the witnesses or because the speaker could simply refuse to authorize subpoenas for those witnesses or documents. So in a way, it does have a serious risk of making things worse from the point of view of due process than we have now. We already have procedures in place for how censure and expulsion can work, which are mentioned briefly at the end of Rule 46. We already have the inherent authority of the House to expel people. This bill puts more hurdles in the way of expelling people who have committed wrongdoing, particularly when they happen to be the speaker or when they happen to be protected by the speaker. This is not the way things should be done. It makes it more likely that representatives will get away with sexual harassment or other scandals and not be able to be expelled. So unfortunately, I don't see any way to fix this bill. It's just too full of flaws and also unconstitutional. So for those reasons, I oppose it. Thank you.
Thank you, Mr. Rose. Any questions of Mr. Rose? Thank you, Mr. Rose, for your testimony this evening. That ends the testimony for today's hearing. Before I call for a vote to adjourn, let me just say that all of the testimony we have heard will be considered in the development of a potential sub-A. Do I hear a motion to adjourn? By Representative O'Brien, seconded by Representatives Vella Wilkinson and Williams. All those in favor? Aye. Opposed? The ayes have it. Good evening, and thank you.